Good morning, everybody. How are we doing?
Hello, how are you?
My name's Kathy Bateman,
And this is Paula Torrey.
and we are Migration Team Australia. Sound like TV show hosts, don't we? Okay, so we thought we'd join you this morning, primarily because we have a huge cohort of clients who we've helped with the 187 visa, which is the Regional Sponsored Migration Scheme, the Rsms, the subclass 187. And we're contacted by our existing clients, but also clients who've had their visas granted either through using another agent or a lawyer, and or doing it themselves. And just to set the premise here, that with the 187 visa, there's actually, within the nomination stage, the employer agrees to nominate the person in a position on the regional occupation list, and that they state that they envisage the position will be available for a 2-year period. If the nomination's approved, immigration state that the employment must commence, usually, generally speaking, within a 6-month period, and the employment should be for a 2-year period from the day the person commences employment. So, for example, if you were onshore, let's say you're on a student visa or a 457 or a 482 now, and you apply for a 187 and it's granted, the employment would start on that day. So you'll have met one of the requirements, because you must start the employment within 6 months, and the 2-year clock would start ticking on that day, if that's your scenario. Everyone's different. We've got people who are offshore coming onshore, so there are very different requirements. That's a very general overview of that. So that what we're seeing is that, as I say, there's this, we'll call it a 2-year post-visa grant obligation period, for the sake of people who are onshore, and that it must commence within a 6-month period of the nomination visa being approved. What we're hearing and getting many inquiries from people who are experiencing issues where their circumstances have changed. So, for example, they've been nominated on a 187, they've been working in the role for 3, 6, 12, 18 months, and their employment has come to an end, or their relationship with their employer has changed. And that's where we're getting lots of inquiries. So we thought, as usual, we like to share. If we hear that we're saying the same thing quite a few times, we love to come to our Facebook Lives and share this information with some of our followers. So that's the premise of why we're doing what we're doing, and the legislation, or the loose explanation of the legislation that relates to that.
And this is covered by the Section 137Q of the Migration Act. There are a lot of information about this in the legislation and policy as well. So basically, the Section 137Q of the Migration Act has 3 subsections. So we're gonna touch very general, so you have this information. So Section 1 is basically, what it says is, if you have not commenced work within the 6 months, as Kathy just mentioned, or you have not made that genuine effort to commence work within 6 months of the visa being granted.
Yeah. Right. So that's one of the grounds for potential cancellation.
Correct.
Yeah. And the second one is, just correct me if I'm wrong, it's where the immigration can consider cancellation if you've not commenced employment within the period that Paul has just specified, and you've not made a genuine effort to be engaged in employment for a 2-year period from the day you commenced employment.
Correct. And the last section is just specify what regional sponsor employment visa is, so which is what Kathy just mentioned. It's about the 187 visa.
Yeah.
So it's very general information.
Yeah.
And also there is more information policy where we, migration agents, lawyers, and case officers, immigration has access to, and it's very useful, right? And it's not legislation, it's not law, but it's policy, it's guidance, and it gives lots of reasons why immigration would not cancel your visa if you are in breach of one of those subsections of the 137Q.
Yeah.
So we, of course, we're not going to list all here, but please contact us if you are in that situation, or if you're thinking about to lodge 187 before you make that decision. Contact us and we can give you more detailed information for you in your
Absolutely.
case.
And bear in mind that the 187 is actually ceasing as of
Correct.
16th of November. So there's not much time left to utilise this particular pathway if you're considering it. And as Paul has touched on, we can't list the specifics. The policy is only policy, and it does not cover all scenarios, and everybody's situation is completely unique and different.
Correct. Even if you fall under one of those reasons, it does not mean that you'll
be successful in overturning a cancellation. So the key point is if you're in the territory of facing a cancellation, you definitely need professional help. That would be my strong advice. If you're thinking about leaving employment within the 2-year period or not commencing employment within the 6-month period, if there are any circumstances or situations that arise that see you falling out of that obligation, so as I say, it's not a condition on your visa, but it is an obligation that the 187 is pretty exclusive on, that could face cancellation of your permanent residency. So yeah, if you're falling into that sort of territory, definitely seek advice on that, because it's a very complex, as all areas of migration law are, a very complex area of the law. And usually when we're talking with clients, it can take us an hour or more to go through that in detail, because we have to talk about their particular situation and give you some information that can help you make some choices potentially to help structure yourself to make sure that you're not going to be affected if that's at all possible. As I say, each case is unique, but we're seeing a huge increase in inquiries. We're hearing that there are certain cases where, and there's a very minority cases that immigration are finding out that you did not complete your 2 years or commence within 6 months. None of our clients have ever been affected, but we're hearing this through our colleagues, esteemed colleagues, some people who've been in the industry for many years, very reputable. So we, again, that's another prominent point just to bear in mind, that it's a real issue, and it's something that you definitely need to address, for sure.
Correct.
All right. So not too many answers here today, but certainly raising awareness on the 137Q. Additionally, just a small point to note that secondary applicants can also be affected. There's a provision within the Act under 137T that includes secondary applicants, even though they may not have been the people who were nominated for the employment. But yeah, so bear that in mind, that secondary applicants also have a potential issue if the primary applicant has an issue. All right.
Awesome.
So I think that's probably going to cover it for us today. As Paula very bravely did a Facebook Live on her own last week, so I was busy, but it was we've been a bit slack on getting in touch with you guys. We've just been busy, which is wonderful for us, which is great. But we're very conscious that a lot of you do rely on some of the information that we share through our Facebook Lives and our YouTube
lots
channel.
Of comments.
Which is awesome. So thanks everybody. Thanks for sharing. Thanks for listening. And as always, if you have any migration queries, we'll pop our email addresses in the footnotes of this live. And
and let us know if you have a specific topic that
you'd like to talk about.
To talk about. We're happy to do it for sure.
Awesome. Okay.
Thank you.
That's it. That's over from us. Have a wonderful day.
See you later.
See you now. Bye bye. Bye bye.